Hey y'all, welcome back to my channel. Thank you so much for tuning in. I hope everybody is having a great day. Y'all, it's the analytics for me. It is the analytics for me. I am at 21 subscribers. Thank you guys so much. I am four bodies away from my goal of having 25 subscribers by the end of the month. I am so grateful and so thankful that you guys are engaging with my content, with likes and comments and subscribing. Y'all, it means the world, seriously. I started this channel as a way to cope with anxiety, and just getting myself out there and discussing things that I find interesting. And I'm glad that you guys are finding it interesting as well. So thank you so much from the bottom of my little heart. Today, as you see by the thumbnail, we are going to be discussing Daryl Brooks, and we are not going to be discussing the entire case and trial because it was just voluminous. But we are going to be looking at what I felt were the most significant parts. And I kind of wanted to tie that into um, things that I've learned in school so far. So we'll see how it goes. I do have a copious amount of notes, so you probably will hear me turning pages just to try to keep up. I am going to have to toggle between different tabs on my computer. So I hope everything goes well. There isn't any lagging or anything like that, but I'm going to do my best, so don't come for me too hard, y'all. But if you do not know who Daryl Brooks is from Wisconsin. He was tried, convicted, and sentenced to 762 years in prison for taking his vehicle, using it as a deadly weapon, plowing through a parade, and unfortunately unaliving eight individuals, one of them being an 8-year-old boy. Additionally, he injured over 62 other citizens of Wisconsin. He is now on appeal, waiting appeal, and he also pled guilty to one count of assault with a deadly weapon against his nephew. And I believe he got a year or so tacked on for that charge. And he's also awaiting the trial for assault, and I think it may be deadly assault against his ex-girlfriend, Erica Patterson. So as you can see, he is a career criminal that gives no shits, no Fs, no shits, okay? And it's not funny. I'm not laughing because what happened is funny. I'm laughing because it's just unbelievable, and I have never in my lifetime seen anything like this. Daryl Brooks is a character. A lot of people like to call him a narcissist. I don't like the word narcissist, mainly because I feel like it's just overused, it's abused with the majority of the people that use the term not knowing what it means. That's not to deter you from thinking or feeling how you want. I just won't be using the word. I just think that he is skillfully manipulative. So we'll just stick with that. Um, so basically what I wanted to try to do is tie in what I've learned so far this semester with this case. So I was given a task to talk about or compare and contrast specific deterrence with general deterrence and provide an example. So, specific deterrence is aimed at a specific individual who is a career criminal. So, let's just say they committed a felony, they were charged, they served time. A specific deterrent would be giving them a punishment that's harsh enough that will deter them from getting in trouble again. Okay. A general deterrent are just our basic laws that we have. So, for instance, if you're caught driving under the influence, depending on your state, your municipality, everybody is going to fall under that statute. So, here in Ohio, if I or anybody else was caught under the influence and I'm operating a vehicle, then I would get a 6 points on my license. Let me see. It's 6 points on the license. I don't think any jail time, and then, like, a small fine of, like, $250. You have to get 4 DUIs in Ohio in order for it to be a felony, which I think is ridiculous, but hey, that's the law. So that would be the general deterrence, and the purpose of that is to just put the fear of God in you so that you think, "Okay, I don't need to drink over what they said because if I do, they're gonna suspend my license," which obviously that's not, it's not a good deterrent because people do it every day. You know, a lot of people feel that, I can control myself under the influence, I can hold my liquor, I'm gonna get behind this wheel. I only live around the corner, nothing can happen. And that's so far from the truth. So in this case, in Daryl Brooks's case, um, I would think that they would use or apply specific deterrents with him dated all the way back to 1999. And unfortunately, society has failed us as it relates to his criminal behavior. And that is what led up to the massacre that occurred on November 21st, 2021. First thing I want to do is I want to pull up a video, and this is of his first appearance where Deputy Attorney Sue Opper goes over his slew of charges dating back to 1999. After we get done watching this, I do want to talk about it. So, this video is probably going to be longer than my other videos, mainly because I do want to comb through his charges. I want to see what type of punishment he received for those charges. And then I want to see how he was able to evade law enforcement, given the fact that he was a convicted felon on probation. So let me share my screen. We're going to go over to the YouTube streets. Let's see. I should have this video saved. So give me 1 second. And I'm gonna be borrowing the video from where am I borrowing it from today? Lord, I am ill prepared. No, this is my history. I don't want my history. Sorry, y'all. I thought I had the video up. Bear with me. Bear with me. Here we go. So this is coming from Fox 6 News in Milwaukee.
Add sparkle to
Add
any
play real
design
quick.
with glitter stickers by Sticker Mule.
All right. All right. So here we go. This is Daryl Brooks' first appearance. I'm not going to interrupt. We're just going to play this about 35 minutes or so, and then we're going to talk about the charges.
All right. Thank you. You can be seated. And could we hold just a second, please? Hold. So folks, we're going to get started. I know emotions are running very high on this case. If you feel like you need to step out of the courtroom, please do. I'll expect everybody to conduct themselves in an orderly fashion, despite some of the allegations you're about to hear. If you feel that it's too much for you to hear, please step outside. Um, Also, audio and visual are not allowed here via the Supreme Court order. We have one camera that's a pool camera. So that's all that we're doing here today. So please refrain from recording or videotaping this. So with that, if we could proceed. This is case number 21 CF 1848.
Darrell Brooks appears in person in custody with attorneys Anna Keys and Jeremy Perry. Good afternoon.
Good afternoon to you. And we are here on a criminal complaint that's now been filed. Mr. Carey, well, Mr. Brooks acknowledged that he has received a copy of that complaint, and will he waive its reading in open court here today?
We have received copies of the criminal complaint. We waive formal reading.
Thank you. It may at some point be relevant, but the address on the complaint is accurate.
That's right.
Thank you. And Mr. Brooks, I have reviewed a copy of this criminal complaint. I will find it does state probable cause as to each of the 5 charges before you. You're charged in count 1 with first-degree intentional homicide. That's a Class A felony, and that has a maximum possible penalty of being sentenced to imprisonment for life. That's for victim A. Count 2, first-degree intentional homicide regarding victim B, is a Class A felony. Again, the maximum possible sentence is a sentence to imprisonment for life. Count 3, first-degree intentional homicide regarding victim C is again a Class A felony, and that's punishable by a sentence to imprisonment for life. Count 4, first-degree intentional homicide regarding victim D, again is a Class A felony, and that's punishable by a sentence to imprisonment for life. Lastly, count 5, first-degree intentional homicide regarding victim E is a Class A felony, that is punishable by a sentence to imprisonment for life. As those are felonies, you're entitled to have counsel. You're entitled to have also a preliminary hearing. And I, again, have found probable cause to each of the 5 counts upon my review of the pleading. So we will turn to Attorney Hopper for her bail recommendation.
Thank you, sir. As to the bail recommendation, Your Honor, I'd like the court to be aware of a prior criminal history as it relates to Mr. Brooks. I can advise the court he has an arrest record from 3 states to include Wisconsin, Nevada, and Georgia. Starting with the state of Wisconsin, the record begins in 2000. There was a conviction in that year for substantial battery, party to a crime. A prison sentence was imposed but stayed for 3 years probation and 6 months condition time. 2002, conviction for possession of marijuana as a repeat offender, sentenced to 50 days in the House of Correction. 2003, misdemeanor conviction for resisting obstructing, sentenced to 20 days in the House of Correction. 2005, there's an arrest from Langlade County. Ultimately, he was convicted of a county ordinance violation for disorderly conduct. What's remarkable about that is that he failed to pay the fine, so he was ordered to serve 30 days in jail on the non-payment. 2009, Manitowoc County conviction for obstructing an officer, sentenced to 2 days jail time served. 2010, conviction from Wood County, Wisconsin. He was convicted of the offense of strangulation / suffocation with other charges of battery and criminal damage to property dismissed and read in. The court ordered a withheld sentence for 3 years probation. That probation was revoked, and on August 1 of 2011, he was sentenced to 11 months jail. 2012, he was convicted at the same time on 2 separate files in Milwaukee County. First file was a charge for possession of marijuana as a repeat offender, sentenced to 180 days in the House of Correction. The second file, he was convicted of misdemeanor bail jumping and misdemeanor possession of THC, also sentenced to 180 days in the House of Correction, concurrent to the other case and concurrent to each other. In May of 2012, there was a conviction for resisting obstructing. He was sentenced to 37 days jail consecutive to the earlier sentence imposed in April of that year. He's currently pending on 2 charges in Milwaukee County. 2020 CF 2550, he's charged with 2 counts, second-degree recklessly endangering safety while armed, and 1 count of felon in possession of a firearm. The date of that offense, or excuse me, all 3 offenses, is July 24 of 2020. It's believed he was arrested shortly after that incident and remained in custody in the Milwaukee County Jail until released on bail there for reasons of a speedy trial violation on March 3 of 2021. Bail at that time was lowered from $7,500 cash bail to $500 cash bail. In that case, Your Honor, it is alleged that he got into a fight with his nephew. The defendant fired 1 round from a handgun toward the vehicle that his nephew was in. The vehicle was occupied by another person, and that accounts for the 2 charges of reckless endangering safety. The next day, he was taken into custody, and the residence where he was located, he was found to have a loaded 9mm handgun just a few feet away from him. The handgun was previously reported stolen. Again, he was a convicted felon on that date, so that accounts for the 3rd charge. He's also currently pending in Milwaukee County case number 21 CF 4596. That has a date of offense of November 2, 2021. He's charged there with resisting, obstructing, felony bail jumping, 2nd-degree reckless endangering safety in a domestic violence situation, domestic DC, and domestic battery. The allegations in that case, Your Honor, are that he struck the mother of his child in the face with a closed fist. Then, as she was walking away from him, he intentionally ran her over with his vehicle. The vehicle in that matter described as what's believed to be the same maroon 2010 Ford Escape used in the allegations in this case. Police went to his home and found him getting out of that Ford Escape. The defendant ignored their commands to stop, and he tried to run into the house before he was apprehended. There's a long history of flight, obstructing, bail jumping type behavior, Your Honor. It's remarkable that these are violations all around the state of Wisconsin, not just his home county of Milwaukee, but we had convictions from Wood County, Manitowoc, and Langlade. I'd like the court to be aware of a record from the state of Nevada. We'll go to Nevada first. That happened, the first conviction was from December 11th of 2006. He was found guilty at trial of a misdemeanor count for obstructing an officer, was sentenced to jail in Nevada. Also on that same day of December 11, 2006, he pled guilty to a domestic battery as a misdemeanor, and the court there ordered a suspended sentence. On March 16th of 2007, he pled guilty to statutory sexual seduction, a felony. The court ordered a suspended sentence for 36 months probation. He was also ordered to register on the Nevada Sex Offender Registry. He is currently noted to be non-compliant with that registration requirement. On June 23rd of 2016, he was charged with a sex offender registry violation, first offense. He failed to appear in court, and a warrant remains active for his arrest. So he currently has an outstanding warrant for his arrest in the state of Nevada. In Georgia, Your Honor, the record reflects a May 27, 2021 arrest for misdemeanor battery with a designation of family violence. While it is not clear if he was convicted, he did recently remark to a court official in this county that he had served a 6-month jail sentence in Georgia. So we have not been able to verify if that was a conviction, but certainly there was a confinement in conjunction with that arrest. He has no contact with the criminal justice system in Waukesha County or the district attorney's office. He does have a outstanding paternity case that's been pending since 2003, in which he was adjudicated as the father of a juvenile. And there's been returned court appearances over the years based on failure to pay child support. The court should know that a warrant or capias was issued for Mr. Brooks in this paternity case on at least 8 occasions. He has been sentenced to jail on several prior occasions for failing to pay that child support. And on one occasion, he had his Huber privileges revoked related to one of those jail sentences. That was back in 2009. Most recently, there was a warrant issued for his arrest in that non-support civil case on August 2 of 2021. Judge Maxwell signed an order for him to serve a 120-day jail sentence. Mr. Brooks did make a court appearance in that matter on November 16th of 2021, so just last week, 1 week ago. And he was released at that time because, again, he had explained to the court, provided an explanation that the reason he had not made his child support payments is because he was serving that jail sentence in Georgia. So the court released him that day and ordered him back for a court appearance in the paternity case for December. So, Judge, just based on his prior record, we obviously have very significant concerns about Mr. Brooks' flight history and willingness to obey the orders of the court. But we have to factor in, obviously, the allegations in this case as well. And obviously, I don't need to state Mr. Brooks is facing 5 consecutive life sentences if he's convicted on all counts in this complaint. I wish to notify the court, sadly, that today we learned of another death of a child related to this case. We do expect a 6th count for first-degree intentional homicide to be issued or added, to this case. I can advise the court that I am aware, I've been made aware through investigators that there are other individuals in critical condition. I think we remarked on the number of actual injured parties in our complaint. It exceeds 60 people. There's a number of other charges that we are reviewing and considering, but certainly at the very least, we do intend to file a 6th count of intentional homicide, maybe Friday or maybe early next week, depending on when we can accomplish that. Certainly if we have any other deaths resulting from this incident, additional.
Okay. So as you saw, just a slew of charges dating back to 1999, and I want to the best of my ability, kind of dissect them a little bit. So, Darrell Brooks has charges from Georgia, Nevada, and Wisconsin. Okay, and they date back to 1999. Oh boy. Okay. Actually, hold on a second. I'm sorry. Let's do this. I made a little slideshow. So, September 1999, Darrell Brooks is charged with substantial battery. So, for those of you that don't know, substantial battery is when there is intent to cause bodily harm. I don't know who the victim was in this case, but I do know that it is a felony. So, this is the charge that solidified him as a felon, and the recommended punishment in Wisconsin for substantial battery is 3 years and 6 months plus a $10,000 fine. Well, Mr. Brooks only received, per my research, he only received 3 years probation, and he only served 6 months in prison or in jail. I'm sorry. He actually did plead guilty to this particular charge, and he did serve out the full 6 months. So in 2000, okay, September, he received 3 years probation and 6 months in jail for, or am I, wait a minute. No, I'm sorry. I'm sorry, y'all. That's when he received the charges, September 2000. Okay, let me get myself together because it's a lot. Okay. So now we're moving to the year 2002 to 2003, and that is when he was charged with two crimes. So possession of Mary Jane and misdemeanor obstruction. So he basically resisted arrest, and this happened in Milwaukee County. So for that particular charge, since he was a felon on probation, he should have got arrested with a prison term. Instead, he only received 70 days in jail. Okay. So now we're moving on along to February 2005. So it seems like for about 2 years, he stayed out the way. Now he's in Manitowoc County, which is a county in Wisconsin, which you may have heard of if you've ever watched um, Making a Murder on Netflix. That is where that crime was committed. So anyway, in Manitowoc County, he fails to appear for obstruction for that obstruction case that he got back in 2002. And so the judge issued a bench warrant. And a bench warrant is when you fail to appear for court and the judge will sign off on a warrant for the ops to come and get you. And so now he is a fugitive on the run. Okay. So November 2006, he is charged with statutory sex seduction where the victim became pregnant. Now I'm saying sex because YouTube is very particular about what words you can use on your channel, and I don't want to get any type of flags or strikes. We're all adults. We know what it is. Don't sit up here and bash me for saying it, okay? But yeah, so the person that he impregnated was 15 years old at the time, and it was his ex-girlfriend, E. Patterson. He now has to register as a SEX offender, which he fails to do so. And so that is when he um does get jail time. It doesn't say how long. I'm assuming maybe a couple years. But what he decides to do is he wrote the judge a letter asking for credit for time served. He went on to tell the judge that, he grew up without a father. His mother was very supportive, and that he was hospitalized at the age of 12 for having a mental health disorder. Now, his mom had mentioned that at the age of 12, Darrell was diagnosed with schizophrenia as well as bipolar disorder. I'm not going to get into that in this video. I want that to be either the next video or the video after, when I talk about his mom and his dependent relationship. But for the meantime, I just wanted to throw that in there. So this is around the time that I believe he started to um use his manipulation skills to um get out of jail. Okay. So in 2007, I don't know if you guys know, I believe it's still on YouTube, but he was featured in a documentary about drug use. I'm not going to say the specific drug, but it is on YouTube. It's called Crystal Darkness. If you want to check it out, it's actually pretty interesting. But anyway, let's head on down to August 2009. Darrell is back in Wisconsin for the obstruction case. He pleads no contest, however, is found guilty. And guess what? Guess what? He's a felon. He violated probation. He only got 2 days in jail. Two. That is laughable to me. I know people that I grew up with that got years on top of years for drug offenses. And you're telling me that this man has obstructed, evaded the police, resisted arrest, caught with Mary Jane as a felon, okay, is a SEX offender, and he only got 2 days for obstruction. This is where I started to apply my knowledge of general and specific deterrence. Because even though the law may say that, he can only do a specified sentence, it wasn't specific enough for him, because all this did was play in our faces as a society as a whole. Because Daryl knows at this point that it doesn't matter what I do, okay? You guys are only going to give me the minimal, below the minimum sentence. And I don't know if it was because of overcrowding in the jail. I don't know if the judge just was flat out negligent. I have no idea how this happened. But it's just it's crazy to me to think that, after each charge, and they're almost happening within a year or two within each other until we get further on down the timeline, that the charges are getting more and more and more intense, right? And the punishment is less. And so I don't see what the deterrence is. There is nothing that is happening as it relates to punishment that is causing him to sit down and say, okay, you know what? I'm not going to do this anymore. When I get out, I'm going to do the right thing. When I get out, I'm going to try to find a job. I'm going to try to get my record expunged. I'm going to try to do right, in society, and do well, and thrive as a citizen. Nothing. There is nothing that is deterring him whatsoever. Okay. So now we're in February 2010. He was charged with strangulation, battery, criminal damage to property. Okay. He got into a fight with a woman. I don't know if it was his ex-girlfriend or another woman. And in August 2010, he thought it was a good idea to plead no contest to the strangulation, but he was found guilty on the other charges. So he was found guilty on the criminal damage to property, and he was found guilty on the battery charge. Okay. Now, depending on the state that you're in, so in the state of Ohio, assault is the wrongful act of causing somebody imminent danger. The battery is just the act of physically harming someone. So I know that sounds confusing or whatever. Regardless of the case, depending upon where you live, the charges can be separate, they can be together, and the punishment can vary. That's the best way that I can explain it because, again, each state has its own statute. I know in the state of Ohio, they tie the two together, and depending upon the severity of the actual assault and battery, that is how you're punished. So in this case, okay, he what did he do, y'all? He pled no contest. He was found guilty for the criminal damage, property damage, and the battery, and the other counts were dismissed as a part of a plea agreement, and he only served 90 days in jail and 3 years probation. Again, I don't understand if he's already on probation, right? You're on probation. Every time you go to jail, they put you on probation. So how is it that you're violating your probation and they don't sentence you to actual prison time? And I don't see anything in here about a fine either. I don't. So that is really interesting to me. March 2011, he's charged again with resisting arrest. The cops pulled him over for not wearing a seat belt. He thought it was a good idea to try to flee the scene. Um, in the car. So he was trying to drive away while the cop was actually, um, how they'll like put their arm in a car to try to reach for, your license or whatever, or they could have been trying to open the door to get him out of the car. I'm not exactly sure, but he did put the car in drive and tried to flee the scene and run the cop over. So August of 2011, I am exhausted. His probation is finally revoked. It took all of those years for his probation to finally be revoked. And even still, with them revoking his probation, he only got 11 months. And this is for the strangulation case. That is crazy to me. May 2012, he pleads guilty to resisting arrest, and he only gets 37 days in jail. This is again in Milwaukee County. Okay. So 2002 was just not a good year for him. He made some very poor choices, but did not suffer the consequence. So they did a sweep in Nevada in 2012 for SCX offender sweep. They found out that he gave them a false address on his registration. And so of course he left Nevada. Um Well, he was arrested because he wasn't in compliance. He posted bail. He failed to appear in court. A warrant was issued for his arrest. Now, here's the thing with that. I don't particularly agree with how they handle SEX offender registration. I believe that if somebody is given a jail or prison term for that specific crime, they should have to register prior to release. You should not be so trusting that that type of criminal with a criminal mind is going to leave jail or prison and say, "Oh, I'm going to go register now." You can't trust that they're going to go do that. So why not let that be a condition of their release? Before their release, make them comply, okay? And do whatever they have to do so that their name is on the registry. Also, as a condition of probation, they already have to have proof that they're gonna be where they say they're gonna live wherever they put down on what I guess the application or whatever it is. That should be notarized. And I also believe that the person or the person's home where they're gonna be living sh come up there and swear under oath, that this is my address or whatever, just I guess to prove that it's not a false address. Now, the person's address or the person that's, swearing under oath to say this is my address, they don't necessarily have to be responsible for producing them in the event that there is a sweep or the probation officer, pops up, but at least have somebody, on record saying, okay, well, this is my actual address. And as far as I know, this person will be, with me. And that's that. So again, the courts let everybody down by believing that he was going to be compliant and not only register, but show up for court after he knew that he didn't register. He knew he was in trouble. And that's why he um, left Nevada. Okay. So nobody knew when he got back to Wisconsin because there was no paper trail um, for his offender status nowhere. They didn't learn that he was a you know what offender until the parade incident. Okay. So Darrell Brooks was able to evade the law for 4 whole years until July 2020 when he was arrested for assault with a deadly weapon, felony possession of a firearm. He was assessed a $10,000 bond. Now, if you don't know the um, possession of a deadly weapon and the incident that occurred with that is he got into a verbal altercation with his nephew at his mom's house. Now, his nephew and his niece lost their mom, which was Daryl's twin sister, at a young age. And so his mom was the legal guardian of the two siblings, so her grandchildren. Daryl, or Darrell, however he pronounces it, got into a verbal altercation with his nephew and decided that it was a good idea to pop inside the car where his nephew and his nephew's friend was. So he was charged with 2 counts of assault with a deadly weapon, okay? So he was assessed a $10,000 bond. However, he has some attorney that is just a buffoon who had asked the judge to set a bond for $500. The judge set the bail at 10,000. So August 2022, Daryl, being a product of the penal system, knew very well what it meant to ask for a speedy trial, and so he did so. And his attorney again argued for a lower bail. The judge sets the bail at $7,500. So now we're in February 2021, where the trial is scheduled for the actual assault with a deadly weapon case, and the trial can't proceed because there's another trial taking place in the courtroom. So this is post COVID when I guess they're trying to figure out like Zoom and all of that. And they're still trying to keep like, the crowds down just for protocol, keeping everybody safe. However, I refuse to believe that. Are you telling me it's only one courtroom in a courthouse? That can't be so. Okay. So since there was this trial going on in the courtroom, they postponed his trial, assessed a $500 bail. His mom went and paid it, and now he's free. So now we're in March 2021, and the prosecution is asking for Darrell to be held in contempt of court for a violation of child support. He has never paid child support. As far as I know, the only child that was supposed to be receiving child support was his first son, Xavier, who is now an adult. The judge gave Darrell Brooks a stayed sentence of 120 days in jail. So, for those of you who may or may not know what a stayed sentence is, basically, Instead of serving time, the offender is given a sentence. In this case, it's 120 days. They are placed on probation. In the event that the probation is revoked, the sentence will be served again. They are so trusting that he is going to comply with probation after he has proven more than 3 times that he is non compliant. He is unwilling and unable to follow the law. So you let him out after he assaulted his nephew with a deadly weapon, after he has been charged with DV more than twice. You let this man out on a promise that he would comply with probation, or he'll only have to serve 4 months until his trial starts. You cannot make this up. We are in May now. May of 2021. He is arrested for a DV case. He makes first appearance in Georgia and he receives a signature bond. A signature bond, for those of you who may or may not know, does not require money to be released, meaning you don't have to pay anything for them to let you out of jail. The defendant promises to return. Now, I understand that this took place in Georgia, a totally different jurisdiction. I get it. But there has to be some changes made and made quickly because there is no way that this man is able to bounce between these 3 states and commit these crimes, felony offenses, and you continuously let him out to go and commit the next crime. I just don't understand. So it's like, nobody's looking up his track record at all. At all. June 2021. We are still in the year 2021 and he is not tired yet. Now he's in Milwaukee. He is in Milwaukee for a status hearing about the 2020 assault with a deadly weapon charge against his nephew. The trial was getting ready to start, but again, they're saying it's court congestion. Okay, so you know what happens? They let him go home. He goes home. He goes home. He goes home to get into an argument with his ex-girlfriend where he punched her in the face. He stole her cell phone and he used his Ford Escape to run her over at a gas station. He's arrested and booked in Milwaukee jail where he has been before. They finally check his background and they finally learn that he has a years-long warrant open for skipping court in Nevada. November 2nd, they finally found out he has an open warrant for skipping court in Nevada. They learned of his recent arrest in Georgia. It didn't appear in the initial report because guess what? Nevada and Georgia had not entered the arrest and the charges. The next day, Darrell calls his mom from the jail, basically saying that if they intimidate his ex-girlfriend, she will not pursue the domestic V charges and they have to drop the case. I will be reading that transcript at another time because I want to do a video solely based on his relationship with his ex-girlfriend. So we're not going to get into that. On the 4th, he calls his ex-girlfriend and not tries to, bullies her into recanting what she told police about the DV charge. The DV incident at the gas station. On the 5th of November, he is formally charged with the DV DV allegations. He also faces the following counts: felony bail jumping, second degree recklessly endangering safety, resisting an officer, disorderly conduct and battery, and some other domestic abuse assessments that were attached to the charges. Now, listen to this right here. The prosecutor looked at the bail that was posted in 2020 in another Milwaukee case and doubled it. He was held on a $1,000 bail. Even though there was a pretrial risk assessment that showed that he was high risk for release from jail and that the bond was inappropriately low. Inappropriately low. He called his mama. His mama came and got him out. Okay. He has a series of hearings in which they kept postponing the trial for the child support, postponing the trial for the DV case, postponing the trial for the deadly assault. Postpone, postpone, postpone. He went on to lie to the courts in Milwaukee about, where he was. He said that he was in custody in Georgia at one point, and they found that to be a lie. This leads us up into the afternoon of November 21st, 2021. All of these years, this man has been able to manipulate the system in such a way that if you add those days up, they barely equal 2 years of time that he has served for felonies. Felonies, okay? This notebook is full of notes that I have taken about this case, and it is just so jam-packed with information that I don't even know where to begin as far as trying to understand any of this, as far as his mom, enabling him to commit the crimes, the DV between he and his ex-girlfriend, the relationship that he has with his nephew, if he has a mental disorder or not. I wanna know what caused him to become a violent individual, and why was his mom, quote, unquote, "supportive" of it? Because she didn't prevent it. She didn't get him the necessary help that he needed, so she enabled him, okay? I wanna know all of that. So I have been taking notes on top of notes on top of notes, trying to figure some things out, and to be honest, a lot of it will never be understood. It is just one of those things, okay? But I just wanted to do this introductory video, um, just to I guess, kind of delve into his criminal past and I guess try to put the final pieces together of how we ended up here. And there are so many pieces to this, like I said, from law enforcement, from the negligence, from the judge, from um, Corona protocol. I don't know if I can say that word or not. Um, just a plethora of things, right? So I want to hear what you guys have to say about it. Do you think that criminals are born or are they made? And why? Let me give y'all some homework. Why? Personally, I feel as though criminals are made based on their environment. I know children who grew up in hell and they turned out to be productive citizens. And I know children who grew up having everything that they can ever wish for, a two-parent home, their own home, a nice backyard, pets, sports, extracurriculars, everything, tutors, nannies, you name it. And they grow up and do the most terrible things. So I want to know what y'all think about that. If you've watched the Darrell Brooks case, I want to know what you thought about that. If there's something that you want me to cover specifically pertaining to that trial, let me know. I'll do the best I can to try to cover it based off of, what I think and how we can use his case as an example for reform. Um, I want to end this by paying a soft tribute to the victims of this case. There were 6 victims, and one of them being an 8-year-old child. Um, and we're gonna pick up on the next video about his mom and how his mom enabled him. So thank you guys so much for watching this video. I know it's long, and I hope you guys enjoyed it. I really do. Um, and so, yeah, thanks again for my 21 subscribers. I do appreciate each and every one of you. Thank you so much for engaging with me and my content, and I'll see y'all next time. Bye.